Good morning, ladies and gentlemen. Welcome to this cycle of conferences on proportionality at the Constitutional Studies Center. We're very happy. Most of us are female researchers, and we are so glad that we have fostered a discussion with the major experts in the subject matter. As you know, we will have 9 days of conferences talking about the test of proportionality. We will talk about amazing, top-notch specialists, people profoundly versed in this topic from different countries of the world. So we're very happy with the quorum we have, and that all these people took our invitation to join us, at least in the virtual modality, to have a discussion on all these topics. As you know, at the Constitutional Studies Center, we opened up a research line with adjustments on the diploma course on the test of proportionality. We've also published 2 papers on our website, and this used to be a permanent seminar, but it has now become a series of conversations throughout 9 days where we have concentrated all the speakers. Today, it's a pleasure to me to welcome Professor Matthias Klatt from Austria. Thank you for being here today with us to open up the conferences, the conference cycle. We appreciate the professor so much at the Constitutional Studies Center. He has been really generous with his time always, and he is an author of one of the publications we have at the center, and we hope he will continue to publish much more with us. It has been a pleasure to get to know him and to share with him throughout these years at the center. He has always been generous and a good person, very giving. It's a luxury to have you today. Thank you very much for joining us. It's such a delight to have you here. Yes, we have around 14,000 people at the event, so it's pretty exciting to have you here. Before I give Professor Klatt the floor, I wish to thank you. I want to acknowledge Dr. Diana Gonzalez for coordinating such a complex event. She had to organize people and professors from different countries in different time zones that will be here with us throughout these 9 days. Thank you very much, Diana. Our appreciation of your work. She will be the moderator. She will take the questions addressed to the speakers. So good morning, good afternoon to those of you in a different time zone. Diana, the floor is yours. Thank you very much. Thank you, Anna. It's been a huge pleasure to be this event's coordinator, and we do hope that you enjoy the conferences throughout these 9 days. We will start with one of the best, with Professor Matthias Klatt's presentation. He is professor of philosophy of law at the Graz University in Austria, and he will talk about the ponderation or weighing of principles of law, or how not to infringe rights without any violations. Thank you, Professor.
Great, thank you very much for this kind and splendid welcome and the introduction. I'm extremely pleased and honored to be able to open this conference with so many distinguished speakers and so many interesting topics. So thank you, and it's my pleasure really to have this audience, and I'm looking forward to discussing with all of you. Now, In this talk, I will give you a kind of general overview on the current state of scholarly discourse regarding balancing as a legal method used in rights reasoning. So unlike my usual approach, I will not zoom in on some detail, some sub-aspect of balancing. Instead, my aim today is to adopt a bird's eye view. I will stretch out before you the whole landscape of balancing. And this will allow you to see the full picture. More importantly, we can address the question how the various elements of balancing are related to each other. The system of balancing is my topic today. But of course, we may focus on any sub-aspect you wish to discuss in more detail during Q&A. Let me briefly comment on my subtitle. The subtitle of this talk, How to Infringe Rights Without Violating Them. Now, this seems to be a blueprint for authoritative states that wish to squeeze out the most of rights holders they can get. How to infringe rights without violating them. Delivering such a blueprint for repressive public powers is, of course, not my aim. Instead, I would like to submit the following point. By drawing the line between infringement and violation, we automatically not only establish how far public authorities can go, we necessarily establish the point where an infringement turns into a violation. And this surely is something that is vital from the perspective of rights holders. This symmetry between the two perspectives, that of public authority and that of the rights holder, is often overlooked. Listen, for example, to the following statement by one of my colleagues in constitutional theory, who I admire very much, Fred Schauer. Quote, "The very fact that balancing is run in one direction and not the other reveals the weighting process. The courts do not typically say that the loss in public order can be no more than necessary in light of the goal of pursuing freedom of expression. But they do say that the restriction on freedom of expression can be no more than necessary in light of the goal of pursuing public order. The asymmetry reveals that there is a presumption at work that the burden of proof is on those who would restrict freedom of expression and not on those who would jeopardize public order." End of quote. So I think this is not true. First of all, the consideration of one-directional balancing fails to consider the frequent scenario of a conflict between two rights. When a right is at stake at both sides of the scales, there cannot be such an asymmetry, such a one way. Second, what courts typically say may be true in terms of an empirical description. In an analytical perspective, however, it does not matter which of the two perspectives of the rights holder and the public authority, which it does not matter, which of the two principles are placed on which side of the scales. We can look at each conflict from the two perspectives of the rights holder or from the perspective of the public authority. There is no asymmetry, but complete symmetry here. Balancing, this is my point, is not a one-way exercise, but it is bidirectional. And in consequence, one cannot derive a particular burden of proof from these grounds. Let us stick with this problem for one last moment. Consider to leave the court's center's perspective and switch to the perspective of a public official. The official knows she is bound to rights. Nevertheless, she wants to impose a restriction on a right in order to realize some public value, to which, qua constitutional principle, she is also bound. While considering the different instruments she could introduce, she may ask, well, is this instrument respecting the right enough? Just as well as, well, is this a different instrument doing enough to develop the public interest? And she may find herself switching back and forth between these two questions, given that she is bound to rights in the same degree as to other constitutional principles. She is even legally obliged to consider both perspectives. I call this symmetry. And I have engaged with this symmetry-asymmetry point in a recent paper published earlier this summer in the Oxford Journal of Legal Studies, a Spanish translation provided by my dear friend and colleague Ruben Sanchez Gil will be published by the Centro de Estudios Constitucionales. So to sum up, for balancing, for its outcome, it does not matter whether one looks at a conflict between principles from one side or from the other side. Symmetry, this symmetry is what I wanted to hint at by my somewhat provocative subtitle. So as you all know, balancing is ubiquitous in the law. Why do we see this vast, almost universal relevance of balancing? The reasons are threefold. First, there is an increasing expansion of material normative content in our constitutions. Second, constitutions are interpreted as value orders of a society, lending them the important function of laying down the most fundamental substantive principles our societies want to live by. And this interpretation goes back to the German constitutional theorist Rudolf Sment. It is now commonplace in many important constitutional courts worldwide, including the German Constitutional Court, who adopted this position in its famous Lüth decision. And third, we accept nowadays that constitutional principles radiate over all other areas of the law. So these are the reasons for the omnipresence of balancing. The analytical structures of balancing have been brought to light by the principles theory. This is a particular school of legal scholarship founded by Robert Alexy. It has many followers around the world in both law faculties and courts. Principles theory analyze balancing, and it has now taken, one could say, the worldwide lead in rights reasoning, leaving alternative methods in the dust. This development stems from the triumphant advance of the proportionality test, which includes balancing as its last step. Now, so far for a little introduction, I have divided my presentation into 4 parts. I will first lay down the specific understanding of principles as optimization requirements. Second, I will present the basic features of balancing, followed by third, a discussion of 4 more detailed problems. And with these first 3 sections, I will have taken you through a tour de force of all important elements of principles theoretical account of balancing. In the 4th and final section, I will then discuss the 7 most important objections against this account. So, first of all, some basic features of principles as optimization requirements. The fundament of balancing is the categorical distinction between 2 types of norms, rules and principles. Rules are definite commands. If the statutory requirements of a rule are fulfilled, then it is definitely commanded to apply the legal consequence stated by the rule. Whether the statutory requirements are fulfilled is a matter to be established by so-called subsumption. Subsumptions frequently require us to interpret the different statutory requirements. This is the reason why the main method for applying rules is interpretation. The problem of whether the legal consequence of a rule ought to be applied is binary coded. It's either yes or no. A conflict between two rules comes about when they require two contradicting legal consequences for a given case. Such a rule conflict can be settled in two different means. Either one of the rules is declared invalid, or an exception clause is read into the rule. Settling a rule conflict in either of these ways will be valid for all cases to which these rules apply. The resolution of rules conflicts is, in this sense, universal. In contrast, principles are prima facie commands. Principles command to optimize something relative to the factual and legal possibilities. For example, the fundamental right to free speech commands us to realize as much free speech as possible. Of course, this command will be limited by the factual possibilities. This is unproblematic. The legal limits of the realization of a principle are more problematic. The legal limits will be determined by countervailing principles. In contrast to a rules conflict, the resolution of a principles conflict is not binary coded. Rather, it follows the maxim of practical concordance. Both competing principles ought to be realized to the greatest extent possible. Both principles are being repelled only insofar as is necessary to realize the competing principle. In sharp contrast to the resolution of a rules conflict, which represses one of the rules completely, both principles remain effective to a certain degree. Unlike rules, principles are not applied in an all or nothing fashion, but in a more or less mode. So it follows that the central task of the person applying the law is this. Within a spectrum of degrees, they have to establish the degree to which the realization of a principle is definitely commanded. And the method to achieve just that is balancing. By means of balancing, we determine which degrees of realization of two competing prima facie commands are commanded definitely. The balancing result will be dependent upon the circumstances of a concrete case, or of a group of cases that are similar to each other in the relevant aspect. In this sense, the resolution of a principles conflict is not universal, like in the case of rules, but particulate. Critics have challenged the interpretation of principles as optimization commands. Optimization commands do not have a prima facie character, but a definite character, because optimization commands can either be fulfilled or not. Either one optimizes or one does not optimize. So this criticism is true. Alexei has answered it with a distinction between commands to optimize and commands to be optimized. To stress the rule character of optimization commands means to interpret them as commands to optimize. These commands are located on a meta level, though. We have to distinguish an object of optimization. The object is located at the primary level. The object of optimization is a command to be optimized. This object of optimization has a true prima facie character, as the principles theory maintains. We can explain this a bit further by the distinction between real ought and ideal ought. Principles denominate an ideal ought, which is not yet relativized to the factual and legal possibilities. The ideal ought indicates an object that ought to be optimized, and this object is transformed into a real ought by balancing. Principles express an ideal ought that is abstract from all countervailing oughts. It is not yet put into relation to the possibilities of our normative world. In contrast, the real ought is an ought all things considered. The process to formulate the real ought is balancing. Now, a legal system can employ both types of norms in many different ways, by including either lots of rules and only very few principles, or the other way around, or anything in between. And this is a decision not at disposal for the person applying the law. Rather, this decision is made by the law-making authority. It is a decision of constitutional design. Theory can, however, give the lawmakers some advice. So rules tend to have a very high degree of certainty and clarity. Therefore, rules provide a relatively stable orientation. They carry high determinative power. Outside their scope of application, however, rules do not command anything at all. For this area, they leave an utmost degree of freedom. Or in other words, they do not provide any orientation. This is the problem of gaps in the law. Rules leave gaps. Imagine a legal system whose design only entails rules. Outside their scope, rules refer the judges then to extra legal standards, most notably to morality. Because the judge cannot avoid deciding by pointing to the fact that the rules do not regulate this case. The flip side of the state's monopoly to use armed force is the right to the citizens to get help from the courts. Without a right to access to justice, we would end up in civil war. So judges have to provide their decision even in cases in which the rules do not apply. There is no way around it. Outside rules, they have to use extra legal standards. Now imagine, in contrast, a legal system entirely designed of principles. Principles have a very wide applicability. They do not leave gaps, because judges will always be able to find a principle applicable to their case. Yet on the downside, principles provide a prima facie orientation only. Prior to the balancing exercise, principles do not establish a definite command, which would lend us clarity and orientation. We could say that based on principles we can decide everything, yet nothing is already decided. To be sure, a reasonable constitutional design wants to get the best from both worlds, clarity and orientation, as much as deciding based on legal standards rather than extra-legal ones. A reasonable design will hence combine both types of norms. When it comes to optimization objects, we have to distinguish two kinds: rights on the one hand and interests or goods on the other. Rights are three-figured relations between a rights holder, a person obligated by the right, and an object. The object can be anything. It does not only entail a wide range of freedoms, like physical integrity, speaking your mind, participating in assemblies. It also encompasses, with regard to each of these activities, both a negative right to defense against infringements and a positive claim to active supporting measures. All rights have the same internal structure, RABG. So we note the letter R for the right, the letter A for the rights holder, letter B for the person who is obliged by the right, and G for some protected object. RABG. A has a right against B to G. Conversely, B is obligated to provide G to A. OBAG. It is obligated that B provides G to A. Now this scheme of rights allows us to see the difference between rights and non-rights protected entities. Interests or goods are non-rights protected. They don't have a rights holder A. Still, the public authority is obliged to provide G. But this obligation is not made towards a person who could claim it. Again, with these interests and goods, the range of objects is very wide. Sustainability of nature's resources, public security. All these interests are two-figured relations of the form OBG. B is obligated to provide G. And the difference between rights and interests is, of course, relevant for the problem whether we have an individual who can claim who can file a subjective claim to court. In rights, we have such a person, but in interests, we don't. Mind you, this difference must not cloud the fact that in a different regard, there is no difference between rights and interests, and this is often misunderstood. Both subjective and objective constitutional law, both rights and interests and goods, are binding. Public authorities are obliged to optimize both. And this is particularly relevant, of course, for all balancing exercises. Balancing must include also interests and goods if they are constitutionally protected. Public authorities cannot avoid considering them by pointing to the lack of a rights holder. Legal norms belong to different hierarchical levels of a legal system: constitution, ordinary statutes, administrative regulations, and so on. Balancing is possible only between principles which belong to the same hierarchical level. It is impossible to balance across different levels of the hierarchy, because we have an ancient rule, lex superior derogat legi inferiori. And this maxim requires a strict preference of the higher-ranked norm. This preference cannot be super-trumped by some balancing. Constitutional rights can therefore only be balanced against principles which are likewise of constitutional status. In contrast, constitutional rights will always trump principles of a lower rank. No balancing is necessary or even possible. Looking at the situation within one and the same hierarchical level, some scholars assume an internal hierarchy among principles, a kind of sub-hierarchy. In particular, within the level of constitutional law, fundamental rights are said to be worth more than non-rights protected interests. Some argue there was a presumption of preference in favor of the right. And in consequence, limiting rights required a reason of special strength, unlike interests, which could be limited on normal grounds. I have already mentioned this view in my introduction briefly. It is the asymmetry thesis. And scholars who maintain it argue also for a restriction thesis. Balancing cannot be applied in order to determine whether a right has been violated. This would restrict balancing to the situation of making a new constitution, because only in this situation it is unsettled which principles are to be protected in the form of rights and which in the form of mere objective constitutional law, mere interests and goods. But as soon as this decision on constitutional design has been taken, all state authorities would be bound to an established asymmetry between rights and interests. Only the pouvoir constituant, in other words, would be allowed to balance. It would not be a method for the pouvoir constitué. In consequence, the practical relevance of balancing would be very, very low. But as I have demonstrated elsewhere, the asymmetry thesis is true only in a very specific understanding that is compatible with balancing. And for this reason, the restriction thesis is also mistaken. I continue now with my second part in order to give you some basic features of balancing according to principles theory. And the first point here is the first law of balancing, which says the more serious an infringement with a principle is, the more important the realization of the competing principle must be. Now, this law allows us to see that balancing consists of three steps. First, we established how serious an infringement with a principle is, for example, an infringement with a fundamental right. Second, we establish how important the realization of the competing principle is, for example, the reason the state relies upon to justify the infringement. And in the third and final step, we compare the results of the first two steps and establish which of the principles gains preference. We use a triadic scale. Both the infringement with the right and the importance of the competing principle can be either light, moderate, or serious. Using the triadic scale, the weights of the two principles can be combined in 9 different ways. For example, a principle of serious weight will gain preference to principles of moderate or light weight. A principle of moderate weight will be outweighed by a principle of serious weight, but on its part gain preference to a principle of light weight. In these 9 situations, there are 3 stalemate situations in which both principles carry the same weight: light, light, moderate, moderate, and serious, serious. These stalemates lead to structural discretion in balancing, very important. The Constitution here does not command a preference of either of the two principles. Still, we need a decision, so we need a kind of meta rule regulating the ultimate decision competence when we have structural discretion. And in democratic legal orders, this will normally be the legislator. The analytical structure I discussed so far allows us to formulate a very precise concept of balancing. Balancing is the establishment of a preference relation between competing principles, and this can be done in a concrete case. Let me explain why concrete case balancing cannot be exercised in the abstract, but only in concrete circumstances. This follows already from the concept of a principle I introduced to you earlier. Balancing, as I said, transforms ideal ought into a real ought. The definite content of a prima facie command will thus be conditional upon the factual circumstances, which, as it happens, tend to vary from case to case. This is the reason why the preference relation that we establish in the third step of balancing will always carry a conditional character. It is conditional upon the factual and legal circumstances of the particular case. Now, many political and practical philosophers have tried to justify abstract and universally valid rankings among principles. If such rankings existed, we had a list of unconditional preference relations, and then there was no need to engage in balancing. However, all attempts to justify abstract rankings have failed, and I think they are bound to fail due to our obligation to do justice to the individual case. Another reason stems from characteristics of our constitutional principles. They come in a very great variety. They carry an internal complexity. They are entangled with each other in multiple ways, so they are prone to compete with each other. All these aspects have been summarized by the great Robert Alexy into a very simple but highly convincing and practical mathematical model, his weight formula. And what you can see here on the screen is also a weight formula, also a good one, but not the one I need to refer to here. This weight formula allows us to calculate the relative weight of two competing principles by means of a quotient. This quotient uses different variables in the numerator and denominator respectively. For this calculation, the values of the triadic scale are represented by a geometric sequence of numbers. Since original invention by Alexy, the weight formula has been further developed and modified. Today, we have several variants. Principles theory scholars still research which and discuss which variables should be included and how their mathematical relation is best constructed. It is highly important that the first law of balancing and the weight formula pinpoint only what I have labeled the internal structure of balancing arguments, the internal justification of a balancing result. But of course, internal justification must be complemented by external justification, and external justification concerns the defense of those arguments which justify the evaluations of weights in the first two steps of balancing. So I would like to stress that all legal arguments can be employed in external justification. There is no such thing as a narrow class of specific balancing arguments. The last point I would like to draw attention to in this part of my talk is the principles level and the rules level. Now, it is clear that balancing is exercised because it concerns principles on the principles level. Yet, balancing does not stand isolated from the rules level. The two levels are connected in a very specific way, and this way is captured by the law of collision. The conditions according to which one principle has preference represent the legal elements of a rule which commands giving preference to this principle as its legal consequence. And then this rule can be applied by means of subsumption. As the legal system develops over time and gets more mature, a dense network of such balancing rules develops by means of a growing number of precedents and scholarly commentary. And this network relieves us from the necessity to engage in balancing again and again as if there was a fresh start. In the next part of my little lecture, I would like to discuss some problems which make balancing difficult, because until now everything seemed to be so neat and tidy. In fact, of course, we do have some problems which make balancing difficult. And one of these problems, I will discuss 4 of them, is the epistemic unreliability. Both the normative and the empirical premises we use in balancing can be unreliable. One way to deal with this problem could be to postpone balancing until all unreliabilities have been settled by further research. Waiting that long is, however, often not possible in legal practice. justice delayed is justice denied. In consequence, we often have to balance on the basis of unreliable premises. Now, to capture the influence of epistemic unreliability, Alexei had included an additional pair of variables already in the very first version of his weight formula. Subsequent research, however, has demonstrated that for reasons of clarity, we have to capture the reliability of normative and of empirical premises separately. Hence, we need two pair of different variables. And these variables also follow a triadic scale, depending on whether the premises are fully reliable or moderately reliable or fairly unreliable. The mathematical model captures these three steps by values of negative numbers, going beyond 0, lower than 0. And that way, the respective capacities of defense and infringements gets lower of a principle, the less reliable the premises are. The fundament of including epistemic unreliability is the second epistemic law of balancing. The more serious an infringement with a principle is, the more reliable must be the premises who justify the infringement. But details here are not yet exactly settled. A second problem. So far, I have only mentioned balancing between two principles, but of course, frequently we experience a conflict between more than just two principles. Balancing must then indeed include all relevant principles. We cannot cherry pick just two of them and leave the others unbalanced. Alexei suggested an extended weight formula for this scenario. It integrates an additive cumulation into the quotient. Newer research of my Hamburg group has confirmed this idea and developed the operative details further. This research was able to demonstrate that we must modify the simple additive cumulation in cases where the principles are not entirely heterogeneous, but overlap to a certain extent. In those cases where we have partial homogeneity among some principles, we need a subtrahend to achieve appropriate curbing effects. In addition to concrete weights, principles also have abstract weights. The abstract weight is the weight a principle has relative to other principles, but irrespective of any concrete case. The weight formula, accordingly, contains two variables for the abstract weights. More often than not, however, it is not possible to differentiate abstract weights of the principles. As you can see here on the slide, they have exactly the same abstract weight. In that case, the variables get assigned identical numbers, so they do not influence the balancing result at all. In contrast, when the abstract weights differ, they must be considered, because they can then potentially justify even an inversion of the conditional preference relation. All this answers, of course, not the question whether the principles do carry, in fact, different abstract weights. The answer will depend on external justification. And here we have two interesting proposals. First, one could use abstract weights in order to differentiate between the whole class of rights and the whole class of non-rights protected interests. The asymmetry thesis, for example, can be reconstructed by assigning all rights a higher abstract weight than to interests. In that case, rights would enter the balancing with a kind of winning margin. This margin does not pose an insuperable barrier against countervailing principles, but still it will become more difficult to justify infringements. This does not settle yet whether such a flat difference between the two classes of principles can be justified. The text of our constitutions, I think, rarely give any indication in this direction. Could we really say that, for example, the principle of the rule of law has a lower abstract weight than the freedom of property? Or that the freedom of assembly carries higher abstract weight than the principle of democracy? So I think the second proposal is more promising. It differentiates abstract weights within the class of rights. It seems to be justifiable to assign a higher abstract weight, for example, to the right to human dignity. Conversely, the general liberty right to act as one pleases, which has a sort of backup or standby function, a subsidiary function. This general liberty right could have a lower abstract weight. And the special liberty rights will then have a moderate abstract weight. But this is all very much not yet settled. Last problem I promised you are formal principles. Until now, I have only discussed so-called material principles. Their optimization object is substantive content, speech, assembly, sustainability. There is, however, a second type of principles, formal principles. The optimization object of formal principles is a competence. So let's take the example of the formal principle democracy. Democracy requires us to optimize the competence of the legislator. Formal principles regulate who is in charge of deciding substantive issues. Formal principles bind other authorities prima facie to an earlier decision made by the competent authority. Taken together, all formal principles form a map of the authority structures of a legal system. This is why formal principles represent a very, very important enhancement of the original principles theory. Yet again, many details are contested, even among the direct followers of Robert Alexy. I could provide more details later in the discussion if you ask me to. I am going to use the remaining time now to present 7 objections. I have a list, and I think 7 is a good number. Let us see whether we go through all of them or for reasons of time we stop slightly early. The first objection against all the account I have presented so far is the incommensurability. Many scholars hold that balancing was impossible because the competing principles are incommensurable. Incommensurability exists if there is no common cardinal scale available for evaluating the weights. We balance, the critics say, apples with oranges. Now, this objection is correct in that indeed principles are very frequently incommensurable. The objection to balancing is still mistaken because balancing does not at all require commensurability. For balancing, it suffices that the principles are comparable by means of an ordinal scale. My Oxford colleague Ruth Chung and my Sao Paulo colleague Virgilio Afonso da Silva have published on this. Comparability may still be lacking in abstract terms, and this is, by the way, the reason why abstract rankings are impossible. But this does not exclude the possibility to compare the principles in specific cases. On the contrary, it brings about the very necessity to do so. And in concrete cases, we can justify an ordinal ranking of principles by means of practical argument. Propositions upon concrete weights are permanently produced, criticized, defended, and reformulated in balancing discourse. That way, a kind of, and this is something fairly new from my recent research, a kind of chain novel with concrete comparability propositions develops. I use Dworkin's chain novel metaphor here. So the mistake committed by the objection from incommensurability is precisely this. It ignores what I have labeled the diachronic dimension of balancing. And it misinterprets a problem of practical discourse for an ontological question. The comparability of values, in other words, weak incommensurability, is not a precondition of balancing, but rather its result. Irrationality is another objection. It denies the possibility to rationally justify the balancing propositions. Balancing would then belong to the realm of merely subjective beliefs. Now, balancing can only be as rational as the arguments that support the evaluations of the weights. I have labeled this the relation of inheritance between those arguments and the balancing result. Shortcomings in the rationality of external justification will inevitably be inherited by the balancing result and weaken its rationality also. However, if you look at the first law of balancing, it offers a clear structure to decide whether this irrationality objection is true. Balancing, we use propositions regarding weights and the relation between them. The claim that these kinds of propositions are generally not amenable to a rational argument is mistaken. The correctness of these propositions can be assessed in rational discourse, and this will bring about a well-reasoned balancing decision. Maybe not in all cases, but surely in much more cases than the critics claim. So everyone who disclaims the possibility to assess the correctness in discourse is ultimately denying flatly the general possibility to rationally discuss practical problems. This, however, is not an objection that could be raised against balancing specifically. Formalism. Let me skip this one for reasons of time, but I'm very happy to come back to it because this one maybe is more interesting at this point. Utilitarianism. Many scholars mistake balancing for a crude consequentialist or utilitarianist account. They overlook that balancing is open towards both utilitarian consequentialist arguments, but also to deontological arguments. As indeed, balancing is open for arguments from any other moral theory. The internal structure of balancing does not limit ourselves to particular moral theories. The sole criterion for the acceptability of an argument in rational discourse is its argumentative strength, which is to be established independent of balancing. In this precise sense, the internal structure of balancing is neutral. External justification, in contrast, is a highly complex and holistic activity that can accommodate deontological just as well as utilitarian standards. So for these reasons, it is impossible to argue against balancing from a deontological perspective. As far as deontological positions are justified, they must be considered in external justification anyway. They are not an alternative to balancing. They do not exclude balancing. Rather, deontological arguments then influence the balancing result in precisely the extent to which they are convincing. And for similar reasons, theories of excluded reasons or threshold values likewise cannot hinder balancing. So I'm actually very eager to give enough room for discussion. And this is why I suggest that I only picture to you, so to speak, the remaining objections, and then it is up to you, the audience and the discussant, to where we go. So mathematization, of course, is an objection specifically addressed against the weight formula. The competence objection argues that balancing leads to juristocracy, taking away the power in the state from parliament and putting it into the hands of democratically unaccountable judges in a court. And the objection from universalism argues against the claim of principles theory that it is a universal, global standard of rights reasoning. And this objection claims instead that it is a cultural, relative thing. And we may even say that the worldwide advance of proportionality amounted to a cultural aggression or something of Western countries. None of these objections is true, but let me conclude. Given the high rank of our constitutions and the radiating effect over all areas of the law, the importance of the method of balancing principles, no matter whether it concerns rights, goods, or interests, the importance of balancing can hardly be overestimated. Based on an understanding of principles as optimization requirements, principles theory has developed a complex model of balancing that is both theoretically well-founded and highly practicable. This model makes explicit the analytical structures of balancing. This model contributes significantly towards making our balancing decisions more transparent and more rational. Given these advantages, the worldwide triumphant advance of proportionality-based balancing, which we have been witness of for several decades now, is neither surprising nor regrettable. Thank you very much.
Thank you very much, Professor Klatt. There's a lot of interest. We have received many questions, so I'm going to try to group them up in categories, and perhaps if there are any similar questions, we can encompass them all. And Professor Klatt touched upon some of the topics that will be further developed throughout this week and a half. So I would like to start with the question we received from Facebook, YouTube, and this specific platform regarding the more theoretical aspect of your presentation that was perhaps implicit. So they are asking you elaborate further on this. If the test of proportionality as methodology is neutral regarding the theory of rights that it stems from, if we need to understand rights specifically as interests or to defend the theory of choice, or can we say that that methodology is neutral in regards to this type of discussions? That is the first question that encompasses some of the theoretical concerns.
Sorry, I didn't get the, is neutral in what respect specifically?
If it's neutral regarding the theory of rights that it stems from. For instance, in order to defend a specific methodology, such as the test of proportionality, is a theory of interest regarding rights required, or can you defend the theory of choice or will, and at the same time defend the test of proportionality as the best methodology to resolve any collisions between constitutional principles?
Okay, thank you very much. I've now understood the question. Shall I answer immediately, or are you rather collecting several questions?
Perhaps we can start, you can start answering this one and I will
Brilliant.
gather more questions.
Okay, thank you. So it is tricky to answer this question, actually. Let me say this first. Yes, in general, principles theory is neutral as to a great variety of theories of rights. By this, I mean it is neutral no matter how you defend, how you justify that we have certain rights. Whether you justify rights because we have certain interests, whether you justify because some authority has made some choice whatsoever. The only precondition that this whole theory has, and this is why I presented this as a system of balancing today, the whole precondition is to interpret these rights as optimization commands. Yeah. No matter how you justify rights by means of whatever rights theory, once you have justified them, you interpret them as principles, as optimization requirements, and then balancing will be applicable. Now, of course, you could say this is not neutral anymore because you have to interpret them as optimization commands. Okay, but then this may be so, but then give me any other interpretation that is better. And I know of no any other interpretation of rights except for interpreting rights as principles, as optimization commands, that is correct. And in that sense, the theory is not neutral. It claims that all rights, however they are justified, are principles.
Perfect.
Great. Thank you very much, Professor, for your answer. In the same train of thought, I will ask the second question we received from social media. If principles are optimization commands, it does not imply that the fundamental theory regarding how the principles are weighed, is it a utilitarian theory? And following up on your presentation about the questions of utilitarianism, isn't utilitarianism a theory of practical reason, but isn't it hostile to rights? If what optimization pursues is improved well-being, happiness, or whatever metric you desire, but on the other hand, rights protect certain interests to the broader degree, as opposed to those actions, wouldn't it end up being an acceptance of utilitarianism when we use a methodology such as the test of proportionality?
Yes, thank you very much. Personally, I couldn't agree more with you. Yes, indeed, utilitarianism is hostile to rights. And this is why, personally, I also like deontologist reasoning better. It is more rights-friendly. However, this is not the field on which we are debating right now. So what I mean here is that I was not arguing in favor of a utilitarian or indeed a deontological rights theory. I was rather making the point that the battle between utilitarianists and deontologists and all others must be fought outside balancing, so to speak. It is not a matter that comes automatically with a proportionality test. again, the neutrality is important here. Um, and this is important to understand because it's a frequent misunderstanding of the weight formula and of law of balancing. People all around the world misunderstands it and think, oh, look, this seems to be some reasoning the rights away, yeah, being hostile to rights and making crude trade-offs and really damaging individual people and who is getting damaged? We're the weakest. And this is not, I understand this reasoning, but this is a misunderstanding to think that balancing would automatically mean being a utilitarianist. Absolutely not true. In the external justification of weights, if you're a utilitarianist, yes, you could use utilitarian arguments, but you will not convince people with this. So in the external justification, you can and should also use deontological arguments. And then the argumentative discourse is open, and whoever has the better strength arguments will win. And I'm confident it will not be the crude utilitarianists, because their arguments are very, very, very weak. But they will lose the battle not because of balancing theory. They will lose the battle because their moral theory of utilitarianism is wrong and unconvincing. So please, final point to this answer, please don't misunderstand and think that balancing would automatically make you an utilitarianist. Many people believe this, but it's not true. You can use deontological arguments a lot, all the way through, and the balancing result will then reflect your deontological standpoint.
Perfecto. Muchísimas gracias.
Perfect. Thank you very much. I will ask you now two slightly different questions, but I do believe they lie in the same orbit of theoretical questions. And after that, we will move more towards more practical questions. The first question from social media as well is if, just as neutrality regarding deontological or utilitarian rights theories, the proposals on the test of proportionality, are they neutral regarding the type of practical reasoning they are based upon, or is there a specific practical reasoning model or moral reasoning model that we defend whenever we apply the test of proportionality to constitutional concerns? So that's the question, neutrality regarding the practical considerations. And a second group of questions revolves around the fact if you can delve into the issue of incommensurability and the fact that principles cannot be compared. Once again, because it seems that the deontological theory on principles may rule out the idea of incommensurable principles because it's maximizing and utilitarian. Perhaps you could elaborate under what terms that comparison is established. What is it? What is the scale? Is it a mathematical scale? Is it of another nature of scale? Perhaps you can elaborate upon that. And what do you mean with the non-raw view of utilitarianism?
Mm-hmm. Okay, thank you. I start with the first question. Is proportionality neutral as to the type of practical reasoning? The easy answer is yes, it indeed is. And I tried to stress this in my talk, although it concerned only balancing, not the whole proportionality test. But yes, in principle, the external justification will be open to all arguments whatsoever you have on the market. So this is this we need to understand because it means we need to detach balancing theory from a certain narrow account on what arguments are good or acceptable. Balancing as such does not come automatically with a narrow group of good arguments. So in that sense, it is neutral and you have complete freedom as to these arguments you use. However, I hasten to add that of course there is an outer limit, or in other words, this open freedom to pull the arguments wherever they come from. This freedom gives you a responsibility. And the responsibility of the person applying the law is don't use rubbish arguments, don't use ideologically arguments. Be really sure that you use arguments that have power, that have strength, and that survive the irrational discourse. So the freedom does not mean freedom to use irrational ideological beliefs. The second part of this question relating whether the incommensurability problem was, and my answer to it, the comparability, would rule out deontological standpoints, I do not think so, because comparability means we come up with an ordinal ranking of the principles. And of course, you could also use deontological arguments to justify such an ordinal ranking if they justify it. As for the mathematical scale, yes, that is a very good point, and I'm very grateful for you that you raised this question because I skipped it a bit in my lecture, because it in a way is similar to the mathematization objection. Many people who follow a deontological moral theory, they would say, look, this use of numbers is totally crazy because dignity and all our great values, equality and freedom, they cannot be numbered. But mind you, the mathematical model of the weight formula does not replace our deontological values. There is no replacement made here. So that in the future we only talk of 3 and 5 and 6 and 9 instead of dignity and equality and so on. It's not a replacement. The values get only represented by numbers. They stay alive and they stay there, and we only use the numbers because it's a vocabulary, it's a grammar we use, and the discourse gets a bit shortened and easier by this. Yeah. So this is important. The deontological values are not replaced but only represented.
Thank you very much. Now we will move on to more practical questions regarding the test of proportionality. There's concern about the universal nature of the test of proportionality. The question is if in different contexts, in different countries, in different legal realities, the operating principles, if they are different, does this mean there's an influence, there's a change in the methodology whenever other sorts of principles are used? And I will link this to a previous question. Or is it because having a clear idea and the practical reasoning and the moral imperative, does that influence on how the test will be applied or on how the test will be used in different realities? This universality includes the local characteristics.
Yes, thank you very much. This is similar to the objection from universalism. So as you may know, principles theory and Robert Alexi and his followers, and also myself, we all claim that the account I have presented to you this morning is universally valid. And universal validity means across all times and across all countries. And I know some of the participants in this room here, including a former PhD student of mine, slightly disagree with this. But I have actually, it's a great pleasure to see you. I have actually tackled this universally versus particularistic point in my fourth paper. It's called Proportionality and Justification, and it is published in an edited volume, Constitutionalism Justified, on Rainer Forst's theory. And if you go there, you will see that I claim in this paper that proportionality and balancing are neither fully universal nor fully particularistic. So let me explain a bit, at least. For sure, what is universally valid is the internal structure, the internal justification, the 3 steps of balancing, the understanding of principles as optimization requirements, and so on and so forth. All this is universal. But mind you, this gives lots and lots of room for local variety, for different societies valuing different principles more than others, and so on and so forth. So in that sense, balancing and proportionality can resonate with a certain local variety of local understandings of what really counts for a society, and also for practical needs of different societies, for example. I mean, take the example of positive rights. Okay, so positive rights in many Western countries, they don't matter a lot. The constitutional theories don't really care about positive rights. No research is being done in Europe, in America, in Canada. Why not? Yeah, well, because right situation is fairly okay. But then in other countries, positive rights matter much more. Maybe they have a higher abstract weight even than negative rights. I'm not saying that this is so. I'm only indicating that there in the theory gives ample room to account for local particularities. But now I must add one more thing. Provided that these local variety and particularistic views can be justified in a rational discourse. Again, this is not a freedom for people to impose right-wing or indeed left-wing ideologies and religious belief and so on that cannot be justified in a rational discourse. So, but again, to strengthen the point, which is my main point here, balancing and proportionality are a form of argument in Rainer Forst's sense for the right to justification. They present a form of argument, and as such a form, it is universally valid. We need to fill it. And to fill the form, we fill the form by local and societal cultural values, provided they can survive a rational discourse.
Great. Thank you very much. This is a question about that is related to the answer you just gave. Where does when is the methodology no longer applicable in specific cases or in specific legal realities? When does the transplantation of this specific methodology becomes a failed transplantation? Is there a point as from where the methodology, the form, the tool is no longer usable as a strategy to solve constitutional problems? The question is, what is the limit? Democratic states, or can we think about authoritarian states with a constitution where we can admit the use of the authoritarian states' constitutional principles, or what are the minimum negotiables, if any, within the constitutions for this tool to work, so it will actually work for the purpose it should serve.
So, in one way, there are no limits for the transportation, as you put it, of this form of argument, balancing and proportionality, into different countries. I am convinced that as a form of argument, balancing and proportionality are universal. Hence, there is no limit. So you may think, okay, then authoritarian, repressing dictatorships may use proportionality to justify their own rule. This is not so. If I was a dictator, I would seek that proportionality and balancing are put into the cellar and hidden in the darkness. Why? Because proportionality and balancing do make clear the quality of the arguments. Proportionality and balancing forces the law applier to lay their cards open on the table. Why is this infringement only low? Do you have reasons for it? Oh yes, and then the dictator says, yes, it's very low because this person belongs to a ridiculous class of human beings which I don't value. Yeah, here we can see that proportionality gives transparency. And transparency is something that dictators and authoritarian states are very much afraid of, rightfully so. So in that sense, it would be a very bad idea for an authoritarian state to use balancing and proportionality as their official rights reasoning ideology. But this is not to say that they don't have to do that. Of course, they have to do it for the sake of the citizens. Critics can use balancing and proportionality theory in order to point very clearly where an authoritarian dictatorship state fails. So it's not the transportation of balancing that fails, it's the practice of a dictator that fails, and balancing will allow us to see that.
I wanted to clarify how weighing works, and there's a recurring question. In order to weigh, do you weigh two principles or rights in conflict, or can you also use that tool in cases where there is no collision between principles, but there's a collision between more than two principles? Because according to what you're saying, Alexi's proposal contemplates only a collision between two principles in the strict sense.
So, of course, in actual life, in the reality, we often have several rights and several principles competing with each other in a given case. Yet the balancing account reduces this complexity in the real world, reduces this to two principles. So the weight formula in its basic form indeed allows only to balance two principles. Still, you could do it several times in a row, right? You could start with two principles, and then you pick two different principles, or one from the first balancing and pull in another principle. So several times in a row, it can be done, and at the end, you will have balanced all principles. In fact, this is exactly how the standard law school procedure is in German law faculties and in German constitutional court practice. Also the Karlsruhe Court, the Federal Constitutional Court, they start their balancing with the most important principles. Yeah, because even though in cases many principles will be competing, more often than not we know immediately which principle is really the affected most. So then also our law students in Germany, they start with two principles, with the most important ones. And then depending on the outcome, you can say, okay, well, there are other principles affected, but I have done the balancing and it's not really plausible that this result will be changed by still another principle coming in and so on. Yeah. So this is an easy way to answer this. The other thing I want to point out to your question is this. We do have a more elaborate version of the weight formula where several principles are balanced at the same time. So not one after the other, but all together. And this balancing formula exists and it is possible to operate it. I indicated there is some new research on homogeneity, heterogeneity of the principles, because if you go to a public assembly to demonstrate for your rights and you have free speech, you have there is a certain overlap between they are not completely separated, and we need to take into account these kind of situations, or in contrast a situation where really the principles, say different rights of a rights holder, are completely separate. Yeah, this all needs to be tackled, but yeah, the extended, more elaborate weight formula for these cases gets very complicated. Yeah, it gets very complex, but it can be done. But so far, principles theory scholars have not yet written so much examples. They have not much used the elaborated weight formula so much. So there we have an open field for new research here, for new PhD topics. But the foundations to consider all this, to consider that we have many rights umbrellas together, the foundations for this are already there. Theoretical analysis. Thank you.
Thank you, Professor. We're reaching the end. So having this in mind, I have one more question regarding your last comment. I get the impression there's a strong intuitive component and in terms of what principles we will compare or weigh. So it's like trying to compare principle 1 and 3. It's like a hunch of students. The Mexican students have a hunch depending on their legal background that says that it's 4 and 2. Is there an intuitive component to this? And or is it, as in mathematics, that the order of the products does not alter the product? Can we compare freedom of speech to privacy, for instance, and will that result be compared afterwards with the right to free circulation, for instance? I would like to know your opinion about this. And finally, there is widespread concern about the implications of the global pandemic and the fundamental rights. One of the concerns and the most recurring questions is, what is your standpoint regarding the obligation of having passports in terms of the test of proportionality and factic global conditions regarding access to vaccination? Do you think that it is proportional to demand people the vaccination passport so they can move between countries? Or do you think it is not so, and why?
Okay, so I apologize in advance if I have not yet, if I have misunderstood the first part of the question. There was some question regarding intuitive components, so that students would pull different principles according to their own intuition and so on and so forth. Well, intuition is normally a method we are critical of, right? We don't really like to justify something with our intuition. Intuition means some irrational belief. So in that sense, the balancing theory would not be very convincing if it relied on mere intuition. But mind you, and I say this only in brackets, mind you, there is also a positive notion of intuition, isn't there? Think of a constitutional court judge who is really near retirement age and someone who has really seen the life and someone who has really decided lots of cases. Such a judge may be a role model for many young law scholars and young law students and young law officials even. And he or she may be a role model for having a good sense, positive intuition. Yeah. So developing over the years a good idea how a case is maybe supposed to be decided. But she, the judge, could never justify her decision by pointing to her own intuition. And nor could a law student write in an exam or something, justify something with an intuition. An intuition is only in the process of discovery. When it comes to justification, you need arguments. And then it will depend. If everything goes well, your intuition is confirmed by arguments. And then the decision is clear. But if rational arguments count against your intuition, then the arguments will win the game. And you need to start reflecting about the intuition. There was also some point on the mathematical use of numbers in the first part of your question, and let me stress again that it's not about an intuition whether it's a 4 or an 8 or a 9 or a 2. The math is just a grammar, just a vocabulary. What ultimately matters is the arguments. So the justification you give with good arguments and also disproving counter arguments, right? Argumentation is not about just saying why you think something is so and ignoring all the critics. Argumentation is always also about of countervailing the critical objections, the counter arguments and so on. So in that sense, it's not mathematical things that matter, but arguments. So, and the last thing of the global pandemic, yes, indeed, and I have been reviewing papers on proportionality and global pandemic countermeasures and so on. So research is moving in this direction. And balancing and proportionality are a very good means to test the measures taken by many states. So in that sense, I can only encourage you all to think in this line of argument. When it comes to deciding concrete cases, though, you ask about the obligation to have vaccinated documentation, documents about your vaccination and so on. When it comes to concrete cases, I hesitate to answer because I stressed in my talk that circumstances matter a lot, and they do. And so from the concrete case you presented to have vaccination documents, I would love to hear more concrete circumstances, which country, how exactly was the regulation made, and so on. How bad was the situation? Obviously, in the country, this matters also a lot. The justification reason is of higher value if situation is very, very bad. Yeah, if you only curtail traveling for people merely because in 10 years it may be a bad situation, then so I'm saying I cannot possibly answer a concrete case here, not knowing the circumstances. So in that sense, I hope you will bear with me sticking to that.
Wonderful, Professor. Thank you very much. We have received an avalanche of questions, and we will save them for next time. I hope we have many, many more occasions to keep on talking about this topic. I don't know if you want to give a conclusion regarding your participation. If so, the floor is yours. If not, we can wrap up.
Yeah, thank you very much for the lively debate. I very much enjoyed your questions. I conclude by heartfully thanking again my hosts, Anna and Diana. Thank you so much. It was a real pleasure to be here with you all. And I think I do need to apologize only to my fellow colleagues who are going to present after me and in the following days. Quite unfortunately, normally if I would be present in Mexico, I would attend you all and discuss. And quite unfortunately, I have a very busy week and cannot stand in front of Zoom so long. So please accept my apologies, my sincere apologies that I don't join you for a longer time. And I'm very much looking forward to meeting you all at a different occasion again, live and in presence and whatever. Good luck to everyone, and thank you very much indeed.
Thank you, Professor Klatt. What a wonderful way to get started with this event, which is nothing else but a conversation between colleagues who are all discussing and thinking about those topics, and people who grant rights within the constitutional sphere and others. Thank you once again. I hope we can meet live in full color. And I want to thank those who joined us in social media, who joined us in the Supreme Court platform. I want to thank our interpreter. Thank you. And remember, you can send out your questions via Facebook, Twitter, via the different social networks. And I kindly invite you to our next session. It will be wonderful, and we will join Professor Andrade Neto and Professor Silva Sampaio talking about universality or non-universality in the test of proportionality. I'll be waiting for you at 11 a.m. Thank you very much.